Welcome to this free immigration help channel. Today is August 12th, 2023, and we are getting into the volume 148 of me answering some of your immigration related questions. As always, before beginning this video, I am gonna mention, as I always mention in every video on this channel, I am not an immigration attorney. This is not legal advice. All the information provided in these videos on this channel are directly from official government sources like USCIS, and of course the Department of State with their visa bulletin. And speaking of the visa bulletin, if you have missed it, the brand new one is already posted for September 2023, and there were some changes specifically for the F2A. I have a video on this channel already posted. If you haven't seen, definitely check it out. Okay, let's start the very first question comment from Sunrise GP3YM. Sunrise, thank you for another comment. As always, appreciate them. As you can see, Sunrise is one of the top commenters on this channel. So Sunrise says, "Hi, just want to tell you that I finished I-864 for my mom." Nice, congratulations, that's awesome. Who is a petitioner? Also finished mine I-864A as a household, and I-864A is basically an agreement, a contract between the sponsors in the household to share income, if you're not familiar with it. My question about my dad, if he should fill out form I-864 as household, it depends. If you want to, for the particular case, if you want to him share the household income, basically become as a sponsor that is part of the household, if that makes sense, then yeah, you can definitely go ahead. But that's really, the choice between you and your dad. And about my question, I put applicant address in part 2. Yes, okay, yes. If by applicant you mean the petitioner, then yes, it definitely makes sense. Thanks ahead. Thank you as always for the question. So there's really not much that I can add to your question. It seems like you got the situation under control. Like I said, I-864A is really more so between, the decision between the household members. And if let's say your dad is the petitioner and you did the calculation and you think that it would be better to show income for both your mom and your dad as a petitioner being your dad, and then as a sharing of the household income, your mom agreeing to show her income as well to supplement to the income of your father as a household income together, then you do that I-864A, which is a contract between the household members to share that income to be used for a particular petition. So as you can see, it's more between the family members, not as a regular I-864, which is between the petitioners and the NVC. But let's take a look at the USCIS. I'm gonna go into the I-864A. I'm gonna open it, take a look at it, just to make sure that we got everything correctly. So, contract between the sponsor and the household member. Yep, this is it right here. Let's open up the form, go through it. So you said you put question, I put applicant address in part 2. So let me double check part 2, make sure. So your household member, I am the intending immigrant and also the sponsor spouse. I'm the intending immigrant and also a member of the sponsor's household. I'm not the intending immigrant, I'm the sponsor's household member. I'm related to the sponsor as his or her spouse. Okay, so I'm assuming you're referring to the part 2 of a different form. So let me know which part 2 of which form you're referring to, and I will take a look at it and make sure that the address that you're putting in there. I'm sure you got it figured out yourself, but just in case, if you want me to, I'll definitely take a look. Okay, so let me put the response here, and we're gonna move on to the next comment from Fatma Abdul Kawi 891. I'm not sure if you answered this question or not. I had an aggravated assault case back in 2019 and the case was dismissed after 6 months. Can I still apply for citizenship or renew my green card since it didn't pass 5 years yet? Please answer me. Okay, thank you very much for your question, Fatma. So whenever it comes to the cases that were dismissed. Now, I personally have not dealt with any of the cases that had any kind of past, misdemeanors or anything like that, whether they were dismissed or not. But as far as I know, if the case was dismissed, then you really shouldn't worry about anything because it was dismissed, which means that it didn't even make it to, it didn't make it past the whatever preliminary hearing or whatever it is that takes place in the criminal court procedure. Whenever it comes to naturalization, most likely the question will come up: what was the situation? What happened? Why why the charges were pressed, in the first place? Why it got dismissed? So if you have all of the documents with you, bring them to the naturalization interview and be prepared to answer those questions. That most likely that will come up. Even if the case was dismissed, usually questions like this still do come up during the naturalization interview. So as long as you're prepared, to answer everything and to give them the reason why, and why it was dismissed, there should be a good reason why it was dismissed, then you should be fine. Now, as for filing, applying for naturalization itself, you do have to wait the 5 year. There is still a requirement, unless I think there is an exception for marriage. I personally, never dealt with cases that have applied for naturalization based on their marriage. As far as I heard, now it might have changed, but the last time I heard about it, it's 3 years requirement. But literally for everybody else, whenever it comes to naturalization, it's 5 years. But you can actually apply for naturalization. You can submit the form N400, application for naturalization, after 4 years and 9 months. So you can apply 3 months earlier. And whenever it comes to the renewing the green card, yes, you can definitely do that. I don't think you're gonna have any problems at all with renewing your green card, because there you are doing the biometrics, and there you do your background check as part of the biometrics, because you do the fingerprint, it goes through the FBI, and then obviously even if your case comes up, it will come up as dismissed, so you shouldn't have any problems with that one at all. So let me post my answer here, and we're gonna move on to the next one from Nicola Lynch. And Nicola, thank you very much for being publicly subscribed. This is what this icon means. Appreciate that. So Nicola says, "Good day. I'm checking if my visa is going to be documentarily qualified. My priority is F3 October 3, 2010. Good job, Nicola. Thank you very much. Appreciate your kind comment. Let's take a look at the visa bulletin, see what's going on for F3, third family preference category. The priority date is in October, in October 2010, which is already 13 years. Let's see what's going on the visa bulletin. I'm going to look at the graph A first. Since it wasn't documentarily qualified yet, we probably should be looking at graph B to see when the NVC portal opens up. So let's start with the graph B first. So F3 for all chargeability area is March 10 as of right now. March 10, and you are in October 2010. So you are very, very close to the NVC portal opening up, where you can start your documentary qualification process. And looks like you're roughly, let's see, March, April, May, June, July, August, September, October. So you're about 7 to 8 months away from your NVC portal opening up and you being able to start your documentary qualification process. And then you are about, this is January 2009, you're October 2010, a little bit more than a year looks like for the availability of the immigrant visa. So looks like F3 is doing pretty good with this gap between becoming documentarily qualified and the immigrant visa is becoming available. So once you're documentarily qualified, that's good news, because you don't have to wait too long for the availability of the immigrant visa, which means that your interview should be coming pretty soon after becoming documentarily qualified. So you're really close, Nicola. I would highly recommend checking out the video that I have on this channel. It's called Documentarily Qualified. What does it mean? I think that's what the video is called, and it's kind of labeled the same as most of the videos on this channel, with yellow, white lettering, and it has the black city, night city, dark picture on the background. So check it out. It's in the video I show, and it goes for everyone who who is not documentarily qualified yet and who will be dealing with it in the near future. In that video I show an actual NVC portal that was already documentarily qualified, and you can see what forms you will need to submit, which fees you have to pay, which documents you need to submit. So the more prepared you are for that process, obviously the smoother it will go. Okay, let's move on to the next question. Looks like 2 comments from the AIM School Dalaza Crowd Pass 7832. I'm the principal applicant. Should I sign as a preparer or not? It's also confusing. No, you don't have to sign the preparer at all. So basically, whenever it comes to and basically what the AIM School, I'll just call that shorter, is referring to is the ending, the very last few pages of pretty much all of the applications, all the petitions from, when you're dealing with immigration process. They do have that. They have, this where you certify the applicant itself, themselves, they certify, they put their signature, the date and everything. And then there are also sections for interpreter and preparer. And yes, it is a little bit confusing because, you are the preparer. Shouldn't you sign that as well? But no, basically those preparer and interpreter is when you're actually hiring somebody is providing service for you as a preparer. So basically you're just sitting there providing the information verbally or maybe in documents, and they are literally preparing that application form, the whole application package for you, kind of like a service. Or there are some organizations that do it for free for certain immigrants, for certain classes of immigrants, and then the interpreter is the same thing, but only kind of with translation services. So they interpret the information and then you're filling it out, or they're filling it out for you. In those situations when it's a third party involved, yes, they do need to fill out their information in those pages. But if it's you yourself, the applicant, or your family members, let's say, you're assisting, let's say your wife or your husband or your mother, your father, or your child to fill out an application, or you're filling it out for them, you don't even need to worry about it. Don't fill it out. Okay, so I've answered this one. Let's post the answer here, and we're going to move on to your next common question. Number of relatives from whom am filing separate form I-730. I'm still confused. I have wife and 3 kids, so what should I write in first blank, and then second, and then third blank? Total forms will be 4. Okay, let me take a look at the form. I'm pretty sure the I-730 is very similar to I-130, where basically, yes, you are petitioning separately for each family member, but in I-130 you actually you do have derivative beneficiaries. So children under 21, for example, if you're petitioning for a spouse, they're automatically considered a derivative beneficiary. You don't need to file a separate I-130 for them. But for I-730, if I remember correctly, I haven't looked at it for a while, so let's take a look. Again, USCIS, official government website for U.S. citizenship and immigration services, uscis.gov. We're going to go to forms, all forms, and we're going to go to 730. See, I think you do need to submit a separate petition for everyone, but let's take a look. If you're a principal refugee admitted to the United States within 2 years, or principal asylee who granted asylum within 2 years, you may use this form to request that your spouse and unmarried children under 21 years of age join the beneficiaries. Yes, join in the United States in circumstances unmarried children over 21 can be. Yes, for more information, blah, 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 blah. Okay, so let's take a look at the instructions and see if we do need to file a separate form for each individual. So children who have reached 21, nope. If you're principal asylee, nope. Your spouse and your unmarried children under 21, whether living inside or outside the United States, are eligible for accompanying or following to join benefits provided that the family members qualify under the conditions. Okay, that makes sense. Let's see. Petition a spouse or child who has previously been granted refugee. Okay, that makes sense. If you need extra space, answer all questions. Let's see. Let me type the word separate here and see if it does say a separate petition needs to be filed. Okay, a separate Form I-730 must be filed for each qualifying family member for whom you are petitioning. Okay, so that answers one of your questions. Yes, in your situation, if you are petitioning for your wife and 3 kids, yes, you will be submitting a separate I-730 for each family member that you're petitioning for. But let's take a look at the I-730 itself and see what you're referring to when you say first blank and then the second and then the third blank. Let's take a look. So we got part 1, information about you, makes sense. Your status, makes sense. The beneficiary is either spouse or unmarried child who is biological child or stepchild or adopted, makes sense. Number of relatives for whom I'm filing separate forms, okay. So here you will say total, right? For example, you know, in your situations it's 4. So for your wife, for example, it's going to be 1 of 4. Number of relatives for whom I'm filing for, yep, 4. And then this is 1 of 4. And then I think this is what you're referring to. First blank, and then second blank, and then the third blank. If this is what you're referring to, let me know. I mean, if this is what you're referring to, you don't have to let me know. Hopefully this is helpful enough. But if this is not what you're referring to, then definitely let me know and I'll look into it. Just let me know which part you're talking about, and I'll take a look and answer your question. But this is what it's going to look. So your first, for example, it's, let's say, for your wife, for your spouse, 1 of 4, right? Total 4. Then the second one for the oldest child, let's say, is going to be 2 of 4. Then your middle child, 3 or 4, and then your youngest child, for example, if you want to go in that order, it doesn't matter really. You don't really need to go in that order, but just as an example, it's going to be 4 or 4. So this is what it's going to look like, and obviously all 4 I-730 petitions you can do in one application package, but make sure that it's each basically separated in a very, very understandable way, because you have to keep in mind that when you send paper applications, everybody sends them most of the times in a very different fashion, right? Somebody puts it on the top, somebody puts it on the bottom, somebody puts it on the middle of the documents. Try to make it as easy as possible for an immigration officer who opens it up to understand what it is. And I honestly would recommend, in your case, I would recommend attaching on the very top a cover letter, very brief, just saying, identifying who you are, and then saying in there that in this application package there are 4 applications for my wife, for my child, this child, this child, this child, and then in the same order you have application, let's say for your wife, the first one on the top, and then documents, her documents pertaining to her case. Then you have your first child, documents, your second child, application, documents, third application, documents, in the same order that they are labeled in those blank spaces that you're referring to, if that makes sense. So hopefully this was helpful. Let me know if you have any follow-up questions, and that goes for everybody else who watches these videos. If you have any follow-up questions, you're more than welcome to ask as many as you have. You know, hopefully I can get to them. Just make sure you don't post them underneath my comment. Don't respond to my comment within your comment, because YouTube does not send me those notifications. Post them as a separate comment under any of the videos. Okay, let's move on to the next question from JJJJJG3858. Do we need to staple our photo on this application if we are sending physically? Okay, great question, Jay. Thank you very much for asking. No, never staple pictures. Never staple anything. If you want to have a separation between, just use the, what are they called? I should have one of those here. Let me see. It's not the staple, it's the, you see, I'm an immigrant too. Some of the words I still don't know. One of these. What are these? Just use one of these. I don't know what they're called, but don't staple it, because yeah, they don't like it. And in fact, in a lot of application instructions, you will see they specifically say don't staple. So if you have an application and you need to attach, you know, a physical picture, just use one of those and kind of, I think it's called clips maybe, just clip it. And if you're creating a separation, for example, you have an application and then you have a separate set of documents and then another separate set of documents, and you want to kind of create like distinction between them. Or for example, if you have like Exhibit A, Exhibit B, which in I-589, you know, application for asylum, there a lot of times they're pretty big, those applications, application packages. So in those situations, yes, again, don't staple anything, use clips, so that just in case, you know, if they don't like staples at USS, I don't know why, but they don't. Okay, let's move on to the next. Looks like a couple of question comments from, looks like there are 3 from Maud Silva 1896. So mine is F4, so category, family preference 4, siblings of US citizen, so sister of a US citizen. Thank you a lot for the insight, but how about Ghana born chargeability? Thanks. Okay, so Ghana born would be all chargeability, rest of the world. So let's see what the third one is. What should I do if my interview date has not been set to me since? After NVC sent email to my brother, the petitioner, that the applicant has been forwarded to the embassy for more than 5 months. Okay, so Maud, so that means that you are already documentarily qualified, and that's it. You are done with the NVC. NVC sent your application package to the US Embassy to schedule the interview. And looks like in your situation, it has been 5 months. Now, because you are F4, forced family preference category, most likely you still have a little bit of time left to wait for the availability of the immigrant visa. Because, you know, in the 4 family preference categories, once you're documentarily qualified, you still have that remainder of time that you need to wait for your priority date to become current on graph A. And now, if we look at the F4, all chargeability, right now it's showing April 2007. So it depends what your priority, it should be somewhere around April 2007. I would say, let's take a look at the graph B if you are already documentarily qualified. So it's March 2008. So if you were already documentarily qualified, I would say your priority date should be somewhere, definitely in 2008, maybe even 2007 possibly. Maybe the end of 2007, beginning of 2008, probably the end of 2007, honestly. I would say you're probably November, December of 2007, I'm thinking, because usually documentarily qualification, you know, it can take like 3-4 months. So March 2008, you know, since you are already documentarily qualified as of August 2023, and you've been waiting for 5 months after becoming documentarily qualified, I would say you're definitely in 2007. So depending on which month in 2007 you are, your priority date, let's say, for example, if your priority date is in, let's say, December 2007, what, you know, the people that are becoming the priority date that are becoming current as of right now, as of September 2023, they are in April 2007, which means that it's, what is it? April is month number 4, and then December is 12, so that's 8 months. So roughly, if your priority date is in December 2007, roughly you have 8 months to wait. If it's in November, then 7 months. If it's in October, then 6 months. So you get the point. So depending on when your priority date is, the amount of time that will, you know, how long you're going to be waiting for the availability of the immigrant visa will depend on that. So if you want, you can let me know, come back to this channel and post a separate comment. Once again, please, so I don't forget, chargeability area, let me know, family preference category, let me know, and the priority date this time, and I'll take a look and I'll let you know. It's still going to be rough estimates because sometimes these things don't move at all. Like, for example, between August and September there was no movement on F4, so it might be a little bit longer, but this is really why you're still waiting for the interviews, because you're, you know, most likely your immigrant visa is not available yet because the priority date is not current on the visa bulletin. Okay, so let me post my responses here and go back up here to Chad Leslie 9955 says, good morning again, sir. I am F3. My priority date is March 2011. The rate the bulletin is going, you think I will get any answers papers from the NVC department? Okay, let's take a look. Chad. Thank you very much for your question. So it's F3. 2011, we're going to look at all chargeability, rest of the world. So let's see, F3. So we still got about, let's see what months that was, March 2011, and this is January. So roughly about 2 more years for the availability of the immigrant visa. But you are just 1 year away from the NVC portal opening up. Just 1 year, because right now, you know, Graph B, and you know, if you want to know more, you know, the difference between the Graph A, Graph B, I have a video on this channel. It's called the easiest way to read the visa bulletin. That's what it's called, I think. Yeah, horrible with sort of terrible memory and terrible with numbers, but I think that's what it's called. How to read the visa bulletin the easiest way. That I'm pretty sure that's what it's called. And there I explain the difference between the Graph A and Graph B. It's pretty straightforward. Graph B is if you want to know when your NVC portal is going to be opening up so that you can start your documentary qualification. Graph A is if you want to know when your immigrant visa is becoming available. So if you want to see the full length of the backlog that you will be waiting for, you're looking at the Graph A. If you are still not documentarily qualified and you're wondering when you can start that process, you're looking at the Graph B. And if you're already documentarily qualified, then you're done with Graph B, you're just looking at the Graph A to find out when your priority date becomes current for the availability of the immigrant visa. That's really it. So if we look at the Graph B, for F3, it's showing March 2010, which means that people, as of right now, September 2023, August, September 2023, their NVC portals are opening up so that they can start their documentary qualification process. Your priority date is in March 2011, which means you are only 1 year behind the current priority date. So another year. Again, it's rough because, you know, there are months like September, you know, F3 did not move at all. Next month we might see some good movement, or we might not see. So it's very rough estimates. But as of right now, 1 more year before your NVC portal opens up. And just like I mentioned to one of the commenters above, I don't remember who exactly, to check out the video that I have on this channel that is called Documentarily Qualified. What does it mean? I highly recommend you check that out, because it's right about time when you can start preparing all of the documents. You know, taking a look into, you know, talking with the petitioner, who will be the sponsor, if the income is enough, what is the minimal income. I do have the video on this channel as well discussing that, so you can calculate all of that, so you can be prepared with the documents, with the fees that you need to pay for the forms, DS-260, affidavit of support. And once your NVC portal opens up, which will be roughly in about a year, you can just in a few days submit everything, pay everything, and be done. Just wait for your, you know, documentary qualification from the NVC, and then that's it. The rest is just waiting for the availability of the immigrant visa and the interview, which is not too far from then on. It's only about less than a year. Less than a year after you're documentarily qualified, your immigrant visa will be becoming available. So you really are close. Still some, well, not still, I would say the most important steps are still ahead of you, but it's really, really close for this whole, I mean, you've been waiting for a very long time. You've been waiting for like 12 years now, over 12 years. So finally, you know, it's all happening. Okay, let's move on to the next question from Avocado5134. Hello, sir. Finally, I got my interview date, and also I got my immigrant visa. Congratulations. That's awesome news. I went with a single status, but now I have another problem. I have a military contract till 2027, which I cannot break. Authority will not break. So I am not willing to go to US till 2027. But if I leave the army unofficially against the law, will there be problem when I enter USA while applying for green card? Wow, Avocado, great question, and I'm sorry you're dealing with this complicated situation. Okay, so man, it really depends. It really depends on the type of the contract and the country that you are, you know, from, because there are some treaties between US and some of the countries where stuff like this will be reported, and you might get, you know, you might get in trouble because they, you know, might create problems here on the border at the port of entry. And, you know, if they do, you know, decide to not grant you access at the CBP because you have a contract in the foreign country military that has a treaty with the US. They will have to send you back, and then obviously over there you're gonna have problems because, well, you try to abandon, basically, what is it called? I don't remember what the English word for it is, but basically when you run away from your military service, you can get in trouble. But if there is no treaty between the US and that country, then no, absolutely not, because US, they if they don't have to report stuff like this, or if this country cannot report to the US or anything like this, then obviously they're not even gonna know. You'll basically just disappear for them, and that's really it. Here's the thing though, you definitely don't want to wait. Whatever you decide, you definitely don't want to wait till 2027 to come to the United States, because the I-551 stamp, it does have the expiration date. I'm pretty sure it is 6 months. It might be a year. That within, I'm pretty sure it is 6 months, but it might be a year. Don't give me check it for yourself. That would be safe. I mean, you can take a look at your passport and look at your I-551 stamp and see the expiration date on it. I think they put it in there, and basically it tells you the deadline until which you have to enter the United States with this immigrant visa, I-551. Once you enter the United States, here's one thing that you can maybe keep in mind. Once you enter the United States, this I-551, it becomes a permanent residence card, temporary permanent residence card. And then within a few, they say within like 90 days, but most of the times it is sooner, you will get your actual permanent residence card in the mail. So what you could potentially do to avoid problems here and to avoid problems in your country, if you don't want to abandon your military service, you could come here, maybe, if that's an option. You could come here, you can get your permanent residence. Once you get your permanent residence, you can go back and you can travel back and forth if you can get allowance to do that. You can travel back and forth until you finish your military service, and then you can come here permanently, and then you can just continue here basically. So if that's an option, maybe you can look into that, but definitely don't wait till 2027, because there, like I said, there is an expiration on I-551, and that's probably the most important thing that you need to keep in mind. And then if you were thinking about abandoning your military service there, definitely make sure that there is no treaty between United States and the country where you're from, where you are doing the military, where they cannot report it, and so that you don't get in trouble. So Avocado, hopefully my answer was helpful. If you have any follow-up, let me know, and I would really appreciate if you can come back eventually. Once you do decide what you're doing, come back to this channel, and I'm sure a lot of people will be interested to hear what happened and what's going on with your situation, because it's pretty complicated situation, and I'm sure a lot of people would appreciate, because I'm sure there's a lot of people that experience similar problems. They get an immigrant visa, but there's something holding them back in their country, and then they cannot leave, and it's complicated. It's a difficult situation, so I would really appreciate it. Okay, let's move on to the very last question comment from Deborah Rimal 4567. How can I change address after approval of I-30? I'm assuming I-130. Please help. Deborah, thank you very much for the question. So the process that is described in this video that you commented on, change of address, immigration process, I'm actually pretty sure there is an updated video on change of address, but your main concern, because you do have an immigration case in process, your number one concern, the number one thing that you want to do is you want to go to uscis.gov, official government website, and go to forms. Actually, you know what, I'll go and I'll copy this link, AR11, there you go, and you can do it online. Just file it online, and that will update USCIS about your new address. So you definitely want to do that first. If your I-130 was already approved by USCIS and transferred to the NVC, then I would also recommend submitting an update to the NVC, and with NVC, once you log into the NVC portal, you have, you know, their email address. You can just send them the email and say, hey, the address has changed, but this one should be sufficient here. And then obviously do the rest with USPS. You know, change your address so that just in case if they send some kind of forms, immigration documents to the old address, it will be redirected to the new address. And then of course you have your driver license, your ID that you need to update. But whenever it comes to immigration process specifically, if you do have any kind of immigration case in process, this is what you want to fill out for the change of address. So let me post a response here. And thank you everyone for tuning in today. As always, appreciate your time. Hopefully you found my answers helpful. Like I said, if you do have any other questions, definitely, you know, you're more than welcome to ask them on this channel. I always appreciate them. As always, thank you for your time. God bless, and I'll see you all in the next video.